Good afternoon, everyone, or good morning, depending on where you are joining us from. This is actually our lunch break here in Geneva, and we are joining you this afternoon from the Permanent Mission of Canada, very near to the United Nations here in Geneva. And just briefly, we are starting in between 1:15 and 1:30 in Geneva, and we waited a few minutes because we had a slight discrepancy in the advertised time. Our poster said 1:15, but the publicized time from the expert mechanism on the rights of Indigenous people said 1:30. So we split the difference and are starting in between those two times. So welcome all of you joining us virtually to our panel discussion on the implementation of the United Nations Declaration on the Rights of Indigenous Peoples Act in Canada, hosted by the Coalition for the Rights of Indigenous Peoples. The legislation that we'll be discussing today became law just a little over a year ago, June 2021, and it's intended to be a legislative framework to implement the UN Declaration on the Rights of Indigenous Peoples in Canada. It's a tremendous honor for me today to serve as moderator for this very important conversation. My name is Sheryl Lightfoot, and I'm an Anishinaabe, a citizen of the Lake Superior Band of Ojibwe. And I'm currently serving as the North American member of the United Nations Expert Mechanism on the Rights of Indigenous Peoples. I am an associate professor at the University of British Columbia, and I'm in the Political Science Department, the School of Public Policy and Global Affairs, and I'm affiliated with Indigenous Studies as well. I'm a Canada Research Chair of Global Indigenous Rights and Politics. And I also serve as Senior Advisor to the President of UBC on Indigenous Affairs. And in that capacity, I've had the distinct privilege to lead the development of the 2020 Indigenous Strategic Plan, which is the very first university strategic framework as far as we know, that uses the UN Declaration as its foundation. And I'm very happy to be one of the leads that's guiding and advising on its implementation across the university. I want to offer a huge thanks to the Coalition for organizing this side event at the Expert Mechanism's 15th session here in Geneva. And also want to offer some special thanks to the Permanent Mission of Canada here in Geneva for providing us a meeting room where we can join you virtually. And they also provided a very nice technology setup for us. So many thanks to them. A quick logistical note, we are recording today's side event. So in the event that you do not, or that you wish to remain anonymous, you're welcome to keep your screen off. And you can even change your name on the screen to something more ambiguous, and that way you can remain anonymous for the recording. We have a very excellent list of speakers on the panel today. And I'm going to introduce each speaker right before they speak. And after the introduction, I would like to invite each of them to take the floor for approximately 10 minutes of remarks. And then after all four of the panelists speak, we will have plenty of time for some respectful dialogue. And please note that you can also put questions into the chat while the conversation is going on, and our team will keep track of them. So without further ado, I would like to introduce today's first speaker, Paul Joffe. Paul is a member of the Quebec and Ontario bars. He specializes in human rights concerning Indigenous people at the international and the domestic level. Internationally, he's been actively involved in standard-setting processes, including the United Nations Declaration on the Rights of Indigenous Peoples and the American Declaration on the Rights of Indigenous Peoples at the Organization of American States. For the past 3 decades, Paul has represented the Grand Council of the Crees and more recently, the Cree Nation government. So Paul, I'd like to turn over the floor to you for the next 10 minutes or so.
Well, good afternoon, everyone. During the past few years, Indigenous
Webseite von EMRIP.
Okay. During the past few years, Indigenous peoples and organizations in Canada have negotiated with the Canadian government a new act to implement the UN Declaration on the Rights of Indigenous Peoples. Its short title, as you see on the screen, is United Nations Declaration on the Rights of Indigenous Peoples Act. Today, I'd like to highlight some key elements.
Just say next slide, please.
Oh, next slide, please. So first, it's important to highlight briefly the significance of the UN Declaration. To date, the UN Declaration has been reaffirmed 14 times by the UN General Assembly by consensus. The Declaration elaborates on economic, social, cultural, political, environmental, and spiritual rights of Indigenous peoples. Now, the UN Declaration has served as a minimum standard or floor in crafting the American Declaration on the Rights of Indigenous Peoples, which was adopted in 2016 at the Organization of American States in Washington, D.C. The American Declaration is a consensus human rights instrument. No OAS state called for a vote.
Next slide, please.
So let's now turn to the new federal act in Canada to implement the UN Declaration.
Oh, sorry. Oh, yeah, you're good.
Just keep going. So to date, the Supreme Court of Canada and most provincial courts in Canada have hesitated to apply the UN Declaration in Canadian law and to affirm Indigenous peoples' rights as human rights. Therefore, sections 2.3, 2 sub 3, and section 4 on this slide send a critical message to Canadian courts that they must take a human rights-based approach that includes applying the UN Declaration in Canadian law. Now, you'll see at the bottom section 4B, and that refers to the National Action Plan that must also be carried out in the new Act.
Next slide.
So this slide includes rules of interpretation in Canada relating to human rights legislation. As a highly regarded law book explains, and you can see the reference at the bottom of the slide, human rights legislation have a special status. Since 1982, legislation enacted to protect human rights has been recognized as having a quasi-constitutional status. The term quasi-constitutional means that such law is more important than ordinary laws. And you'll see in number 1 that human rights legislation and protected rights receive a broad interpretation, while any exceptions and defenses are narrowly construed. So those are the rules, legal rules, how you interpret human rights legislation. And number 3 at the bottom adds that in cases of conflict or inconsistency with other types of legislation, the human rights legislation prevails. Next slide, please. So in the new federal act respecting the UN Declaration, the new general standard is that the Government of Canada acts in consultation and cooperation with Indigenous peoples. And that's generally required in the UN Declaration. The simple duty to consult, as interpreted by the Supreme Court of Canada, is not served to guarantee Indigenous peoples' rights in Section 35 of the Constitution Act 1982. In this regard, you can see at the bottom of the slide that the UN Declaration, Article 38, is clear that the general standard in the whole declaration is consultation and cooperation to achieve the objectives of this declaration. And this also includes legislative measures. Next slide, please. Now, as highlighted in the references in the top quote, there are a number of federal laws, you can see them listed, that there are federal laws in Canada that explicitly affirm that Canada recognizes that all relations, not some relations, but all relations with Indigenous peoples must be based on the recognition and implementation of the inherent right to self-determination. And that includes self-government. At the bottom, we have a quote from the former UN Special Rapporteur, James Anaya, who underlined in July 2009, self-determination is a foundational right without which Indigenous peoples' human rights cannot be fully enjoyed. Next slide, please. Now, this preambular paragraph is in the Federal United Nations Declaration Act. And it affirms that the Canadian government is committed to a wide range of effective measures, not only in Canada, but also internationally, so as to achieve the objectives of the UN Declaration in consultation and cooperation with Indigenous peoples. I'll just mention that the practice in the past has been that when we went internationally, when Indigenous peoples went to international forums, often the government from Canada did not collaborate very much at all with Indigenous peoples. This doesn't apply to the current government, but that really affected making progress on the UN Declaration. Now, next slide, please. So let's turn to the living tree doctrine. I love this doctrine. As early as 1930, Canada's Constitution had been described by the Privy Council in the United Kingdom. It used to be that the highest court of appeal for Canada was the Privy Council. That isn't like that today. But at that time, the Privy Council, what was mentioned is that the Constitution Act is like a living tree capable of growth and expansion within its natural limits. And that's really important since Indigenous rights and Indigenous ways of life always are evolving. So it doesn't make sense to have human rights in a static context. It has to be dynamic. And more recently, in 1984, the Supreme Court of Canada emphasized, and I quote, you see it at the bottom of the slide, the Constitution is drafted with an eye to the future. It must be capable of growth and development over time to meet new social, political, and historical realities, often unimagined by its framers. The UN Declaration is a new social, political, historical, and I would add legal reality unimagined by the original drafters of Canada's Constitution. Next slide, please. So Section 35 of Canada's Constitution Act includes Aboriginal and treaty rights. And in this top paragraph on this slide, Canada's Act on the UN Declaration includes the same preambular paragraph here that exists in the UN Declaration. in regard to inherent rights. However, the new Canadian law adds that Indigenous peoples' inherent or pre-existing rights includes Indigenous peoples' legal systems, and I bolded legal systems because that's the big, huge change in a positive direction. Therefore, Canada's Act now confirms that there are 3 orders of government in Canada's Constitution: federal, provincial, and Indigenous. And this would be a big change in the way that the courts interpret Indigenous rights and also Indigenous governance. So at the bottom of the slide, we have a quote from the Royal Commission on Aboriginal Peoples, who had its report issued in 1996, and it confirms the same thing. It did that well before what we're doing now. And it says that Section 35 of the Constitution Act serves to confirm the status of the Aboriginal peoples as equal partners in the complex federal arrangements that make up Canada. It provides the basis for recognizing Aboriginal governments as constituting one of 3 orders of government in the Constitution in Canada. Next slide, please. So, in conclusion, Canada's Act respecting the UN Declaration includes a number of positive elements. We can use the UN Declaration and this Act consistent with Indigenous sovereignty, governance, and laws. We can interpret Indigenous rights and state obligations, including Section 35 of the Constitution Act 1982. So this is important in terms of Canada's obligations to Indigenous peoples. The new Act affirms minimum duties of consultation and cooperation, not solely consultation, is still applied by Canadian courts. Also very fundamental is that it fills in the gaps in treaties and other agreements between Indigenous peoples and states. And the Declaration can certainly guide policy development, negotiations, and litigation. And hopefully with this Act, Canadian courts will pick up on the fact that they have to apply legally the UN Declaration. And lastly, it can guide Indigenous nation building and strengthen Indigenous communities. Thank you very much.
Thank you very much, Paul. I think that was an excellent place to begin, giving us a good foundational understanding of the legislation, its history, its rationale, and also its implications. So that's a wonderful launching point for the rest of our conversation. So I'd like to introduce our next speaker, who will be joining virtually. Celine Henry is a Métis woman and citizen of the Manitoba Métis Federation. Celine has a Bachelor of Arts degree with a double specialization in women's studies and political science, as well as a certificate in Aboriginal legal education from Laurentian University. She studied law at the University of Ottawa and holds a Bachelor of Laws. She was called to the Ontario Bar in 2005. In 2009, she joined the Department of Justice, and she currently works as counsel for the Department of Justice Aboriginal Law Center. The Aboriginal Law Center is a center of expertise that specializes in Aboriginal law, including the interpretation and application of Section 35 of the Constitution Act 1982. So Celine, you have the virtual floor for the next 10, 15 minutes or so.
Thank you very much for that introduction. I'd first like to acknowledge the Anishinaabe Algonquin people whose traditional lands I'm speaking from today. Tanse Celine Henry Nitsegasan. I'm counsel with the Federal Department of Justice Canada, and I'm happy to be here today to discuss the implementation of the United Nations Declaration on the Rights of Indigenous Peoples Act. As you know, since May 2016, Canada has fully supported the United Nations Declaration on the Rights of Indigenous People. Canada is committed to its full and effective implementation in accordance with the Canadian Constitution. The implementation of the declaration corresponds to an important step to respond to the Truth and Reconciliation Commission's call to action 43 that calls upon the federal government to fully adopt and implement the United Nations Declaration on the Rights of Indigenous People. It also responds to the call for justice of the National Inquiry into Missing and Murdered Indigenous Women and Girls. As was mentioned, the Declaration Act came into force on June 21st, 2021, and it provides a framework for advancing the implementation of the UN Declaration on the Rights of Indigenous Peoples in partnership with Indigenous peoples. The UN Declaration Act seeks to protect and promote Indigenous rights, including the right to self-determination, self-government, equality, and non-discrimination, in order to build stronger relationships with First Nation, Inuit, and Métis. This work is important for Indigenous peoples and for Canada's future. Indigenous peoples from around the world have worked on the UN Declaration. For some individuals, it has been a part of their life's work. The UN Declaration Act is tremendously important, and it's a step in the right direction because it includes requirements to take action and work with Indigenous peoples. Métis legal scholar, Professor Larry Chartrand, has said we're moving from Canada doing 2 Indigenous peoples to doing 4 Indigenous peoples to now doing with Indigenous peoples. The UN Declaration Act moves us forward in creating an action-oriented framework to advance the federal implementation of the UN Declaration. Action is what Indigenous peoples are calling for. The reality remains that in communities that are facing dire circumstances, the coming into force of the UN Declaration Act has had little immediate impact, and it can feel like just another government initiative. I know this reality and community, but I also have hope that this act will be transformative, and this will be generational work. There's a strong push to get things going with the action plan developed with Indigenous peoples, and it will take years to see the full effect of the UN Declaration Act, but I believe it will have a positive impact on Indigenous peoples and settlers alike. The commitment and now legal requirement in the Act is to ensure that there will be continued progression of work over time. The Minister of Justice, David Lametti, has said this legislation is intended to be transformational over the long term and will impact almost every area of the federal government's work. The inclusion of both consultation and cooperation, terms that are pulled from the declaration itself and placed in the Act, reflect a more collaborative exercise between equal participants towards a shared objective. The Act is meant to promote a cooperative approach, which will take some time. Practically speaking, the UN Declaration Act provides this procedural framework for ensuring that the laws of Canada reflect the standards set out in the Declaration, while also respecting Aboriginal and treaty rights recognized and affirmed in Section 35 of the Constitution Act 1982. The Act also affirms the Declaration can be used to interpret and apply all Canadian laws, including the Constitution. It therefore means that all new laws, policies, or revisions to laws and policies should be undertaken in a manner that contributes to achieving the objectives of the Declaration, both in terms of substance and the process through which they are being developed. There are 3 fundamental specific obligations in the UN Declaration Act that require the Government of Canada to work in consultation and cooperation with First Nations, Inuit, and Métis peoples. These are: first, the Government of Canada must take all measures necessary to ensure the laws of Canada are consistent with the Declaration. Secondly, the Minister of Justice must prepare and implement an action plan to achieve the objectives of the Declaration. This is found in Section 6. The action plan has to include measures that Indigenous peoples identify through the consultation and cooperation process, but it also must include measures to address injustices, combat prejudice, and eliminate all forms of violence and discrimination against Indigenous peoples, including elders, youth, children, persons with disabilities, women, men, gender diverse, and two-spirit people. It also has to promote mutual respect and understanding, as well as good relations, including through human rights education. And the related monitoring and follow-up and recourse remedy, oversight and accountability with respect to the implementation of the Declaration. Finally, the Minister of Justice must adopt or develop an annual report on progress and submit them to Parliament, which contributes to accountability. The first of such reports was tabled in Parliament on June 21st, 2022. The current ongoing process of consultation and cooperation with Indigenous peoples was launched in December 2021, and the Act requires that the action plan be developed as soon as possible and no later than June 2023. Through the consultation and cooperation process, it's anticipated that key priorities for the implementation of the Declaration will emerge. The UN Declaration Act changes the approaches, and the consultation and cooperation process isn't a one-sided evaluation of what is required for Indigenous peoples. The consultation and cooperation requires good faith and ensuring Indigenous peoples' perspectives and processes are respected. And this process is ongoing. The obligations arise when proposals intersect with the rights in the Declaration, whether or not the government believes it may be potentially inconsistent with the rights and interests mentioned in the Declaration. It's essential to obtain Indigenous peoples' perspectives on the issues, and this consultation and cooperation should begin as early as possible in the development of any initiative and be conducted in a broad and multidimensional manner. Obtaining free, prior, and informed consent is about making every effort towards mutually acceptable arrangements, enabling Indigenous peoples to genuinely participate in and influence the decision-making process. It's about building broader agreement and working together in good faith. Indigenous lawyers have told us that they would much rather the Government of Canada approach them with an idea so there can be a discussion about implementation, rather than starting with pre-drafted bills or initiatives. With the UN Declaration Act now in place, we need to hardwire the consciousness of the public service that the requirement for early consultation and cooperation with Indigenous peoples as early as possible into every Government of Canada departmental policy development process. All departments need to know who the key Indigenous experts and organizations are, and it's important for each department to develop their own relationships and networks relevant to their own areas of responsibility. The Government of Canada fully recognizes that this can be challenging work. We hope that the UN Declaration Action Plan process may help clarify some new mechanisms through which consultation and cooperation can take place. There's room to grow, to continue to renew and strengthen the nation-to-nation, Inuit Crown, and government-to-government relationship, including through respect for the collective and individual rights of Indigenous peoples. Indeed, as Minister Lametti said during the parliamentary debates on the UN Declaration Act bill, one measure of success of this legislation would be that we're all a lot better at this type of cooperative work going forward. There's so much potential for Canada in all of this work. It's why we're very much looking forward to working with Indigenous peoples more broadly to start making a real and lasting progress and upholding rights and advancing reconciliation through all that we do. Thank you. Thank you all. That's it for now.
Thank you so much, Celine. Really appreciated hearing the detail about the Act's provisions and, of course, emphasis on the expectations, behavioral expectations of the Act, emphasizing cooperation, consultation early and often at major junctures in building partnerships and relationships. Thank you so much. I'd like to turn to our third speaker, who is in the room in Geneva with us, Sashia Leung from the British Columbia Treaty Commission. Sashia is Wet'suwet'en and Chinese from the community of Wet'suwet'en and is Director of Communications and International Relations at the BC Treaty Commission. In her role, she manages the public information and education mandate of the Treaty Commission and is one of the leads for its international work to support implementation of the Declaration and Indigenous rights recognition. Since joining the Commission, Sashia also facilitates First Nations governance initiatives, community engagement, and capacity development. And I'll just add a personal note. She was once upon a time a student of mine at the University of British Columbia. So it is my deepest pleasure to welcome you to the table and give you the floor for the next 10, 15 minutes or so.
Tanizet, Sakazet, Skyzet, Hati, Sait Sozi, Sashia Liang. Thank you for having me here. Thank you, Sheryl, for that lovely introduction, and to Paul as well as Celine for covering a lot of the national, federal UN Declaration legislation. For those of you that are not familiar with the BC Treaty Commission, I will provide a bit of an introduction and way of background, and you can go to the next slide, please. Thank you. So the British Columbia Treaty Commission is an independent body that advocates and facilitates for the recognition and protection of Indigenous rights and title through the negotiations of modern treaties, agreements, and other constructive arrangements amongst participating First Nations in BC and the governments of Canada and British Columbia. It was established in 1992 through agreement of the BC-TC Agreement and subsequent provincial and federal legislations and statutes. Its primary mandate is to be the independent facilitator and funding authority for the negotiations and provide public information and education on treaties and agreements. Since 2018, its mandate was expanded to support the negotiating parties with implementing the UN Declaration on the Rights of Indigenous Peoples, the Truth and Reconciliation Calls to Action, the federal principles respecting the relationship with Indigenous peoples, and the recognition of Indigenous rights and title. In line with Article 27 of the UN Declaration, the BC-TC negotiations process framework is a fair, independent, impartial, open, and transparent negotiation process to reconcile and achieve the coexistence of federal, provincial, and Indigenous jurisdictions, laws, and legal systems. Next slide. Oh, and sorry, I was remiss. The BC Claims Task Force report, of course, is its blueprint, and that was achieved in 1992. And since then, and then it'll be next slide, thanks. We have a strong foundation and innovation for reconciliation in BC. After the BC Claims Task Force, and more recently, we were able to achieve the first public tripartite policy named the Recognition and Reconciliation of Rights Policy for Treaty Negotiations in British Columbia, which was achieved in 2019. And there are a number of other listed policies, and of course, including the United Nations Declaration on the Rights of Indigenous Peoples, the Declaration on the Rights of Indigenous Peoples Act, and the United Nations Declaration on the Rights of Indigenous Peoples Act. So those are just highlighting a few of the foundational pieces that support treaty negotiations and reconciliation negotiations in BC. So I had thought that Paul might have covered the BC declaration, so I quickly tried to add in some information. So I apologize that there isn't a slide that speaks to it, but on November 28th, 2019, the provincial government passed the Declaration on the Rights of Indigenous Peoples Act, or DRIPA, or Declaration Act. It was co-developed with the Indigenous nations, including the First Nations Leadership Council in BC. It is the first legislation in Canada that implements the UN Declaration. Fully implementing the UN Declaration also requires a sharing of sovereignty between Indigenous nations and the Crown. Its purpose is to affirm the application of the UN Declaration on the Rights of Indigenous Peoples, contribute to its implementation, support and affirm and develop the relationship with Indigenous governing bodies. Similar to the federal legislation, DRIPA sets out a process to ensure that provincial laws are consistent with the rights defined in the UN Declaration, as well an action plan to achieve the objectives of the Declaration, and an annual reporting on its progress. Where it does differ from the federal legislation, it does include provisions for agreements, and specifically decision-making agreements, which are often viewed as consent agreements. On March 30th, the government of BC released its Declaration Act Action Plan, which was developed in consultation and cooperation with Indigenous peoples, and it outlines 89 specific actions to create a better province for Indigenous peoples in BC. So my presentation, next slide, will focus primarily on the negotiations process in BC. I was asked to share a bit of how both the legislations impact the work of the Commission. And since September 2019, since the endorsement of the rights recognition policy as well, 2 months then thereafter, the DRIPA Act was passed, and then last year we did have the federal legislation come into force. We have seen direct impact and progress at negotiation tables and in community. We are seeing renewed commitments and new mandates operationalizing the declaration. It has reaffirmed the Treaty Commission's mandate to facilitate treaties, agreements, and other constructive arrangements. Innovative approaches beyond the classic treaty model, which has also encouraged new First Nations entering the negotiations process. We've seen re-engagement of stalled negotiations that are now focusing on new approaches to tripartite reconciliation and incrementalism, and as well increasing pace and progress to conclude advanced negotiations for ratification. The landscape of rights recognition in BC has changed dramatically, probably the most that we've seen since Section 35. And First Nations in BC, some of course, and not all are in the BC treaty negotiations process, but some do feel as if the process is a pathway and structure to self-determine, self-govern, assert their rights and title, and begin the implementation of the UN Declaration. Next slide. And so I did want to highlight that if you do go onto our website and take a look at the last few of our annual reports, we did include recent MOUs, accords, and agreements that reference the implementation of the UN Declaration, not just in policy, in negotiation milestones as well. And although many of them were achieved prior to the DRIPA Act, the DRIPA Act came into force 2 months after the rights recognition policy, and they were really done in tandem with one another and complement one another. And the Treaty Commission believes that the rights recognition policy, of course, in conjunction with the two legislations, provide an important and viable and comprehensive mechanism to implement the UN Declaration through concrete policies, negotiations, and agreements. And it's our hope also as well that in the next 1 to 2 years that we will have concluded agreements that will be the most innovative post-RRR policy as well as UN Declaration legislations, and will serve as good practices for implementing the UN Declaration. And next slide. So because we are now 3 years since the RRR policy, 2 years, almost 3 years from DRIPA being in force, we're seeing a lot more progress in British Columbia than I would say maybe, in other parts of Canada. And so I focus a bit on some specific things that we're also seeing at negotiation tables. And so the whole of government approach, is a big conversation because for far too long, there's been colonial mindsets. And in BC, the principles, so the Government of Canada, British Columbia, and the First Nations Summit of the negotiations process recognize the necessity to move beyond historic legacies of Crown denial, unilateralism, and the doctrine of discovery to a new nation-to-nation relationship based on recognition of rights, reconciliation, respect, cooperation, and partnerships. The Indigenous Crown relationship is not with CERNAC, respectfully, or with the Ministry of Indigenous Relations and Reconciliations in BC. Upholding these sacred agreements and entering into good faith negotiations requires a whole of government approach with engagement and support from all ministries is absolutely paramount. And we're seeing this at the negotiations tables. Since the declarations have come into force, it has changed the environment in which we negotiate and recognize Indigenous jurisdiction and sovereignty, and has forced government departments to move beyond antiquated positions and find new ways of recognizing jurisdiction. So there's more creativity in the negotiations. They're coming with more openness, transparent, meaningful ways of addressing recognition. Treaties are flexible living agreements, no longer full and final, no more extinguishment, surrender, and they're finding new pathways forward through the development of mandates as well as other innovations in incrementalism. However, of course, we are very early on and we have to begin somewhere, and the negotiations are complex, and co-development has been helpful, but it has also been a bit of a challenge and has slowed some progresses in some instances. We still find that some departments are unwilling to engage and lack the experience and capacity to negotiate with First Nations. There seems to still be old attitudes that First Nations are stakeholders, and we're working on changing this, and we'll continue to push government to have a whole government approach. Now, on the other side of things, though, there is progress being made. So we do have progress in renewal provisions, committing the parties to new relationships and addressing gaps in treaties and agreements, as well as new language and general provisions explicitly addressing non-extinguishment and affirming recognition. And I'm going to skip over some examples. I know we're tough for time. But I did want to also highlight in the BC Action Plan, Action 2.1, it does commit to setting up a secretariat. Since then, there is a Declaration Act Secretariat, which I think will be of interest for others to keep an eye out for. Its purpose is to coordinate and assist the cross-government effort to work in consultation and cooperation with Indigenous peoples to align provincial laws with the UN Declaration as per Section 3 of DRIPA. So aligning laws with the Declaration, reporting to the minister, it will be independent and it is distinct from the minister or the Ministry of Indigenous Relations and Reconciliation. And its focus also, interestingly, is that it is actively recruiting Indigenous leaders and staff. I think they're trying to go for about 18 to 22 staff members. Its core functions will provide assistance to ministries to meet consultation and cooperation obligations in the development of reform of legislation, ensure the alignment of laws with the UN Declaration, as well as develop processes and measures to support the alignment of laws. And next slide. Okay, And then, this is my last point, I did want to focus on Article 37 of the UN Declaration, the right to the recognition, observation, and enforcement of treaties, agreements, and other constructive arrangements concluded with states, and it is over 40, so I'll just shorten it there. So to say that both these legislations have affirmed its commitments to renewing and strengthening the treaty relationship for both modern treaty nations and First Nations in BC with early treaties. And we're seeing this at the negotiations tables, and you can also find one agreement, this is the name of MOU, which is in our annual report, which acknowledges that Canada and British Columbia have committed to implementing the UN Declaration, including Article 37, committing to renewing and strengthening the treaty relationship as set out in the Douglas Treaty of 1854. So this is a bit of a nuance as well. I do also want to highlight, next slide. Yes, it is, sorry. I do want to highlight as well, coming out of the action plan, the shared priorities framework that was recently signed between the government of BC and the Alliance of BC Modern Treaty Nations, which establishes a shared path for advancing modern treaties and renews the commitments to timely, effective, and appropriately resourced implementation of modern treaties. As we know, treaty implementation and honoring treaties across Canada has had its challenges and its gaps, and certainly as well in BC. So this demonstrates the changes of attitude and whole government approaches to honoring treaties and providing certainty as well to the negotiating nations that are currently in the process. And furthermore, that treaties, agreements, and other constructive arrangements are living agreements and will continue to evolve over time. This framework does address three broad outcomes, looking at specific gaps around fiscal arrangements to fulfill treaty rights and obligations, meaningful involvement with treaty nations in legislative and policy initiatives, as well as comprehensive organizational and policy changes in public service to advance whole government approach to treaty implementation. And as well, the reporting will be included in the annual reports of the DRIPA and the action plan, and that concludes my 3 points.
Thank you so much, Sashia. Very important to talk about the BC Act, as it did precede the federal act in Canada, and also the act. Thanks for sharing about the action plan, which, as far as we know, of course, is the world's first UN Declaration action plan. So those of us who live in BC are very proud of that fact, and thank you for sharing with us, and also sharing the important changes and progress in the BC Treaty Commission as a result of all of these changes. I really appreciate hearing everything from the Secretariat to the whole government approach and the partnership model. Thank you for sharing all of that in less than 15 minutes. Well done. Thank you. And now I have the great pleasure of introducing our final speaker. And he is joining us from Vancouver, and we've had a few tech difficulties. So I'm going to ask first if Chief Littlechild is in the Zoom room. Okay, we are going to go to Plan B, which is while I'm introducing him, we're going to get him on the phone. So I'm going to go ahead and provide it's hard to give Chief Littlechild a brief introduction, so I'm going to make it as brief as possible, but his lifetime of achievements in this area is astronomically long. So it is my pleasure to introduce our fourth panelist, the distinguished Grand Chief Wilton Littlechild. His role in this work goes back as far as 1977, when he was a member of the Indigenous delegation to the United Nations. And he worked for many years on achieving the UN Declaration on the Rights of Indigenous Peoples. In 2009, he was appointed as a commissioner to the Truth and Reconciliation Commission of Canada, where he served for 6 years until the Commission's final report in 2015. Chief Littlechild has been, among other things, a member of Parliament, Vice President of the Indigenous Parliament of the Americas, North American Representative to the UN Permanent Forum on Indigenous Issues, and my predecessor, and he actually served as chairperson for the United Nations Expert Mechanism on the Rights of Indigenous Peoples as its member from North America. He's also served on the Commission on First Nations and Métis Peoples and Justice Reform, and as I mentioned, amongst his many roles and accomplishments. So I believe we have Chief Littlechild on the speakerphone, and we are going to turn over the floor to you, Chief Littlechild.
Good morning, everyone, or good afternoon, good evening, whatever time zone you're in. Can you hear me okay?
Yes, we can. Yes,
We
yes.
can, and we're getting nods on the Zoom, so we're all good.
Okay, thank you very much, and it's a great honor to join you. I apologize. I have 3 machines in front of me, none of which would allow me to link in so that I could see, and you could see me on video. Nevertheless, it's a great honor for me to join briefly this very important, I don't call them side events, I call them special events, because of the importance that they hold during both the Permanent Forum and EMRIP or any other fora that we're participating in. It was a tremendous challenge, opportunity, and a welcome success to work on this legislation that we're talking about today. Usually, as you all know, I'm sure, when an international treaty is agreed to by states, what's most important is not only the adoption of the legislation, but the implementation of the legislation. So in Canada, for example, we had a migratory birds convention treaty between Canada, US, and Mexico. And in order to implement it within the country, we had to have legislation, national legislation, called the Migratory Birds Convention Act. That then implemented the international agreement within the country. This is a very similar experience now in terms of implementing the United Nations Declaration on the Rights of Indigenous Peoples in Canada through legislation federally. It is, I would say, at the beginning stages, because there are elements in the legislation we still have to clarify. And let me just make one example, and that is with the role of the provinces in implementing legislation. We do have, for example, in Alberta, legislation that has not only supported and endorsed, but adopted the UN Declaration, but we were waiting for the implementation legislation, so now that we can work together both federally or with the Crown in both federal and provincial governments and Indigenous governments in implementing the rights contained in the declaration. What I find very encouraging for me when you look at the legislation is a very positive approach. I always say that it's encouraging in terms of the references that we don't normally see in the national or federal legislation. There are examples, of course, I can't remember the numbers, but I did at one point just survey the bill before adoption, and the times that we use the word implementation, the times we use the word reconciliation, peaceful coexistence, treaty. It's very encouraging for me anyway to see the number of times that we use previously adopted international wording in the bill, and there should not be any further debate on those words because they have already been accepted international legal language. But to have the specific words implementation, treaty, reconciliation, peaceful coexistence, and so on, those kinds of words are very positive in terms of moving forward. And I look forward to this implementation because when we did the Truth and Reconciliation Commission, for some of you who may not be aware of it, it was a court-ordered mandate to have a Truth Commission on the history and legacy of the Indian residential school policy in Canada when it was legislated assimilation by taking children, like myself when I was 6 years old, put into an institution, separated from family, my parents, grandparents who raised me for 14 years. And what happens when you do that to a child? What happens to the parents from whom you've taken the children? And what happens to the children who come after through intergenerational trauma? So to have that as a background, the first principle for reconciliation being the adoption of the UN Declaration is very significant in terms of advancing reconciliation in Canada, because the second part of the court-ordered mandate was not only to search for the truth, but how do you design a path, taking that information, a path of reconciliation. And what is reconciliation? We need to jointly agree on that definition. And what we, as commissioners, proposed was restoring respectful relationships. And I really look forward to that opportunity with this legislation to do exactly that, to advance better relationships with Indigenous peoples and non-Indigenous peoples in our country. It's a unique model because it's the first time in history that a court ordered a Truth Commission to be established. A first time to look at what happens to children when they're apprehended and put into an institution where it exposed them to a lot of physical, mental, cultural, spiritual, and worst of all, sexual abuse as children. So to have this truth known from a previous categorization of the most unknown, darkest, saddest chapter in Canadian history is really a positive opportunity now with this new legislation that was just given royal assent, and that is to advance reconciliation through all segments of society, different aspects of society. For example, private industry, who at the beginning were quite resistant in terms of cooperation. But now you see academia, you see the justice systems across the country, you see governments, both federal, provincial, including municipal and indigenous governments, asking the question, how can we take these calls to action and implement them? And one of the calls to action, as a principle, is the UN Declaration. And this moves us on, this legislation moves us on forward on that journey. But the key thing, in my view, is that we have to do it together. We have to advance reconciliation together. And by that I mean either as government to government or nation to nation or peoples to peoples, within our own families, within our communities, with our neighbors, with the Crown relationship that, for example, the Métis have, and the Inuit, and of course with us, some of us who have existing treaties. So it's a real positive future, I believe, once we get down to the actual sitting down together and coming up with solutions on how we go forward together. And there's many examples across the country right now where the academia has gotten together. I remember, for example, one province with 5 universities and a number of colleges who had never gotten together before, but now have gotten together for the first time, asking each other, how do we work together in advancing reconciliation? So we have, in my case, my bias, professional sports, playing a very active role in implementing the legislation by what they're doing in terms of advancing reconciliation. For example, on the ice, the National Hockey League teams have been really engaged. The football teams in the Canadian Football League, at least at Edmonton, and the baseball teams. In fact, on July 1st, just a couple of days ago, the professional baseball team had jerseys, new jerseys they wore for the game to focus on the children that went missing by wearing jerseys with large letters, and in the back, every child matters, and in the front they acknowledge the territory of Treaty Number 6 and a logo of the treaty medal right on the uniform of the baseball team. And the example that for the provincial government of Alberta, who some of you may know was quite resistant at the beginning, then adopted it, begin with planting a tree on the grounds of the provincial legislature, and that will be expanded into a garden where people visit and learn about how do we get along better together. So this legislation is really unique It comes from a dark spot in Canadian history, but shines a bright light on a positive future. And that's what the legislation, as I see it, will be the outcome. And recently, a second piece of legislation, which was a missing piece on this journey together, walking together in peace and reconciliation. While there was a lot of good initiatives undertaken by academia, for example, the faculties of medicine, education, law, making it mandatory that all students study about the UN Declaration, that all students study about the Crown-Indigenous relationship, racism itself, and how it's related to this, the different doctrines, the papal bulls that have been mentioned several times in different fora. Even at the expert mechanism a few years ago, more than once, it was suggested that that be the focus of study. On the other hand, Permanent Forum picked it up and made it a special session. So there's a lot of good examples of what's going on, but the missing piece is no one is monitoring all the good activity. And the monitoring is important not only to build capacity across the country of awareness of our history, of our contributions to the country. Building the awareness comes, of course, together with better understanding of each other. So the judicial community, for example, asking themselves, how do we, through the court system, advance reconciliation? That we must take into account when an Indigenous person is in front of a judge. The question has to be asked, is there a history of the residential schools within that person facing the judge? Before, there was what's called a gradual case, and questions were asked on that basis. But then with the IPLE decision, the residential schools also now have to be raised in the courts. So the judicial system is trying their best. The Law Society in Alberta, for example, is making it mandatory for all the lawyers, practicing lawyers right now, all the law students, to study about this sad chapter of Canadian history, to build the awareness. And what happened, we saw at the beginning of the Truth and Reconciliation, was less than 5% awareness in the country. When we finished and filed our report, it has gone up to, I believe, close to 60%. But when Kamloops happened and missing children and unmarked graves were discovered, it went up to 93%. So the awareness level has really gone up. But what is missing is an independent oversight body to bring together all of these good initiatives so that we can learn from each other, or some that have not started an initiative, to learn what others are doing and maybe pick something up from there that they can do. We usually tell them, take one call to action that speaks to you. Make a commitment on how you are going to implement it together with Indigenous peoples. So the legislation on the national establishment of a National Council for Reconciliation was just adopted very, very recently. Now add to that the new UN decade on Indigenous languages and the establishment of an interlocutor recently, Tim Murray, who was now responsible for the challenging assignment of the missing children and unmarked grave, which is ongoing work, and she will be focusing on that issue. So from the implementation legislation of Bill C-15, the interlocutor looking at the new discoveries, the new legislation of an independent oversight body called the National Council for Reconciliation, all are coming together at the right time. My criticism is that they're a little bit late, but nevertheless they're there now. And you will see change in the country. You will see change in relationships in Canada because of this new legislation. It's really important that we continue to have dialogue, especially with youth, about these new developments in our country. The implementation legislation, the interlocutor, as I said, the National Council for Reconciliation, and the very positive approach that is undertaken in the language of Bill C-15. Yes, we've been critical for many years. We've criticized when we needed to, states and their activities, but we always came with solutions. And here you have 4 immediate solutions that are now underway in Canada, and I pay tribute to all the panelists that are on. I can't say, for me it's very, very early in the morning, which is okay because sunrise ceremony is just about to start at our National Chiefs Assembly. So
Chief Littlechild, I hate to interrupt you. I hate to interrupt.
I'm going to stop right now by saying these are solutions. They're not problems. We didn't go to the UN for 43 years to create problems, but to create solutions, and that's what we have now. So thank you very much. I apologize for taking so much of your time.
Thank you so much, Chief Littlechild, and thank you for getting up so bright and early in the morning in Vancouver and phoning in. And I want to thank each and every one of the speakers for their unique and important contributions. We've covered a tremendous amount of ground, and we have 10 minutes left on the clock. So I would like to invite questions, discussion, conversation. We can do that in 2 ways. You can, if you're on the Zoom and want to raise your hand and ask a question directly or engage in conversation with any of the speakers, please feel free. We also have the chat open, so that's another option. I would like to, while we're waiting for folks to join in, I would like to invite the speakers to comment. Is it possible to develop an action plan without legislation? What work does the legislation do for us in Canada? Do you think we would make progress on an action plan without legislation provincially or federally? I invite any of the speakers that would like to jump in on that question.
Well, I will talk about the, are you talking about the 2-year action plan that's supposed to be developed together in Canada as a follow-up in the legislation?
Yes, before you got on, Chief Littlechild, Sashia Leung explained about the BC action plan that has just been announced, of course, and then the federal action plan that is in progress.
Yes, I think really for me, we need to jump on that opportunity together. For example, I think there has to be a very important inclusion of the public inquiry and the calls for justice on the murdered and missing Indigenous women and girls. This is the opportunity, I think, to move forward together again and deal with a very tragic issue which is still ongoing. And the action plan needs to include that. I think it needs to also include matters like implementation of treaties that exist, included in fact in the Constitution of Canada. How do we go forward with those? But I wanted to look at perhaps the 2 years to begin a decade plan, because it's going to take more than 2 years, of course, to do the work that needs to be done. And that's why I mentioned the International Decade on Indigenous Languages. How are we going to implement that? What are we going to do to reinvigorate or revitalize our languages as a part of the National Action Plan? Because for many elements of the declaration, oral testimony in our languages is very important. Not only that, but for our sacred and spiritual ceremonies being very important to our languages. So those are new opportunities, and I'm glad the legislation was tabled to establish that, so that 2-year action plan can be developed alongside the global action plan that's being developed at UNESCO for our languages. So there's agenda items of work that we need to do that can be included and incorporated into the National Action Plan. The role of the provinces, for example, they're going to be called on to give reports on, for example, the status of Indigenous children within the province. And then the report to Parliament, annual report to Parliament on the status of where are we with the reconciliation and required response from the Prime Minister. All of those are really important elements of an action plan that'll take all of your expertise, all of you on the panel and others in the audience. Our collective expertise needs to be put forward in that, so that we can begin to activate the solutions that we have proposed for years, so that they become action within the country.
Thank you very much. Paul, did you want to offer a brief comment?
Sure. I'll keep it brief. But what's really positive in all of this is we have some critical elements, and Chief Littlechild spoke about a lot of them. One of them is positive language on human rights. It means that when parties would engage in colonialism and subjugation and denial of rights and discrimination and ignoring key issues like murdered and missing Indigenous women, now we have a whole different context that we agree on. It's positive. The language is positive. The instruments that are coming out are positive. The initiatives like missing and murdered Indigenous women, doing the study by women to get out there and to expose the real challenges that we still face. So now we have all these positive elements, and we put aside unilateralism, colonialism, subjugation, harm to Indigenous children or women or Indigenous men or Indigenous nations. And all of this has been really affected. So we have so many opportunities. It's a question, how do we challenge it? How do we perhaps at times parcel it out and then join it later with a bigger picture and have all these positive interactions begin to happen? And the other thing we've done is we're not limited to the domestic context of Canada or certain provinces. We can go internationally. The language of international human rights complements everything that Willie and other speakers have mentioned. And Celine focused on cooperation. So we can take the word cooperation or the whole concept of cooperation and give it international elements, domestic elements, community elements. We can do whatever we want with so much rich principles and legislation, and also showing respect for Indigenous visions, laws, and perspectives. I'll stop here.
Thank you very much, Paul. Unfortunately, that is the end of our time together today. So I want to offer a couple closing thanks. I want to thank the Department of Justice for taking part in this conversation. And I think what we've demonstrated by our participation in this panel is the principle of partnership and cooperation and collaboration. And so I want to thank you very much for being a part of the conversation today. I want to give one more thanks to our speakers that were in the room and on the speakerphone, joining us from many locations. I want to say a special thanks to the man behind the scenes, Jeremy Vanderhoek, who is handling all of the technology for us back in Ontario. So thank you so much, Jeremy, for your expertise in keeping everything running smoothly for us. And if you wouldn't mind, could you just drop into the chat the link to the Coalition's website so that everyone has it. I believe the video will be posted there later on, and so you can access this or pass along to your friends and colleagues after this event and once the video is posted. I want to just close us out by saying one more time a special thanks to the Coalition for Indigenous Human Rights for organizing this side event, or as Chief Littlechild called it, our special event for this afternoon. And of course, thanks to the Permanent Mission of Canada here in Geneva for hosting those of us in the room and providing us the space to have this conversation. So thank you all for joining us at whatever time it is, wherever you are. For those of you back in Canada, I want to wish you a very lovely morning and a good day. And we in Geneva are going to head back into the UN for the afternoon session. Thank you so much.